We've got a slight amendment to the programme at the moment because before we invite Professor Pandey and then Professor Rao to talk and then open it up for more general discussion, when I'd like you to be able to direct questions to all of those panellists because we've run out of time earlier. We want to ask Bharti if she will come up and just give a 10-minute presentation, which I think is of relevance to the whole programme. So please go ahead.
Very good morning to all of you. I would like to discuss in these 10 minutes the kind of work which we have been doing under our business right now. We started it 2 years ago, and the journey was really interesting. We started with our work of getting prisoners released from the jail on technical ground. We picked the easier type of cases and petty cases because we knew it. To start with, it's good to start with those cases in which we could bring out results in a limited period of time. And within a short span of 3 months, we could get 8 people released. And my student presented their cases before the court. So how we started doing that? We called for the data. That was not really easy work. We were not that happy to share their data with us earlier, but once they started trusting us, they shared their data, then we shortlisted them, interviewed each one of them, then we shortlisted those cases in which people were involved in petty cases. And then came the second round of shortlisting, in which eliminated those prisoners who were involved in multiple cases. Because even if we get them released on one case, they could not have come out of jail because they were required in other cases. So the second round of shortlisting bring it down to 10 cases, and the next challenge before us was like from where to get the case files. Because jail authority doesn't keep the legal record. They just have the record of the person when he was admitted to and when he needs to present it before the court. They didn't know, they had no access to their court files. So only the court had the court files and the advocate who was appointed in their case. So getting a case file from a court when we were not the authorized attorney was near to impossible. So we thought of contacting their advocates, and we convinced them that we would like to work with them, assist them, and this way my student will get to learn the practicality of the law. They got agreed to it, they shared the case file with us, and we presented the case before the court with them. But in some of the cases, advocate didn't turn up on the day. So we requested the court to let us stand before it and present the case. But we are in a stronger position because by then we had studied the case file. We knew that we can get the relief because we know the facts and circumstances of the case. And there's one provision in the Advocates Act which says that if the court is convinced that this person requires representation, so they can authorize even a person who is not an advocate. So as those cases were not of a complicated nature and it could have been brought before the court only on the petty application. So they allowed us, and our students presented their cases before the court and got them released on personal bond. They had already been granted bail, but they were inside the jail because they were failing to furnish the local surety. And we have a provision which says that if a person fails to furnish local surety, he can be allowed to produce a native surety, or if not, then he can be released on the personal bond, provided his address is verified. So they verified the addresses were verified, and they were released. And the day when the order of the court came in, and all the students' name was there on the paper of a court, on the order of the court, so it was very motivating for them. And this is how we picked the momentum. Because earlier even the students were not convinced, like, can we do something? When the advocates and like people who have the license to work, if they are failing to do something, if it were that easy, everybody could have done it. And when we don't even have a certificate, advocate's license, how can we do it? Will people take us seriously? Will they listen to us? But we were strong, determined to move ahead, and we moved ahead, and we could bring in the relief to the people which they deserved. After that, then the way we worked, everybody was very happy with the kind of work which we were doing, and particularly the jail administration, because I have found that in Delhi jails are overcrowded, so even they want to reduce the population of the jails. So they said if we could do more work for us, so they gave us more work to do. So that one project brought in many other projects to do it. Second project which we took up was like impact assessment of the reformation and rehabilitation program. They said ultimate objective of keeping prisoners in jail is to rehabilitate them and finally to reintegrate them into the society. We teach them skills, we have many vocational training courses, we have many factories. And the turnover of the factory shows that it's increasing day by day. But I really want to, the teacher of Tihar said that I really want to know, is it actually helping people? Is it actually reforming people? And if I ask my staff to ask the prisoner, I might not get the real, authentic information. So I want a third minister to come and scrutinize my work. So we interviewed 8,100 prisoners. She said, I don't want to take the random sampling. I really want to listen to each and every person. So everybody who has stayed in a jail for more than 3 months should be interviewed. And once we were done with the interview, we analyzed the data. We also asked for their suggestions, like if you have any suggestion how the administration can work in a more efficient ways. Then we compiled all the suggestions and the data that gave very authentic picture of the administration of Bihar prison. And majority of the suggestions which we gave have been implemented. And one of those suggestions was setting up the disabled friendly ward. Because in all the public offices, it is mandatory that if a person, like they should provide disabled friendly facilities. The moment a person steps into a prison, there is no disabled friendly infrastructure available to him. That's a different thing. He has been sent to jail, but still he possesses basic humanitarian rights. So they said it never came to our mind. Nobody brought this point to us. So there were many suggestions which they actually implemented. And after that, they gave some more projects to do. Another one was setting up open jail in Delhi. We don't have open jails in Delhi. And some other states, like 8 states of India has open jails, but in Delhi we don't have. So they said if we could help out in drafting the open jail rules, because we have interviewed so many people, we have access to the problem of these people, like how we can set them. So we have already submitted the draft rules of open jails to them. And at the time of fixation of the rules, they take that into consideration because they really appreciated it. And that could have been possible because we had done the intensive research in the prison. In the light of the experience which we gained from the data which we collected, and by interviewing with the prisoners, we could draft very efficient and like very practical rules of open jail. The current project which we are doing is the death in the judicial custody, which is increasing day by day. In 2012, only 70 people had died in the judicial custody. In 2013, it was 37. And in 2014, by now, by the end of September, it had reached 37. When I inquired them, like, why is it happening? They said, we are expecting it to reach 50. So the very statement that we are expecting it to reach 50 gave me a clue that they know the reason why is it happening. Then only you can say that it can reach, we are expecting it to reach 50. Then we started our work with reading the documents. Then comes another challenge. They said, we will not share the files with you, like we will not let you take away our files. You'll have to come and sit in our office and you'll have to read. We'll give you one file, read it and give it back. And no photocopying allowed, no scanning, nothing, you just read it. Because if you publish it somewhere, then it can lead to a problem. And whatever we are noting down, that's a secondary document. And it doesn't have much of a relevance because we can write anything we wish to. So, but we wanted to start a research work. We said, okay, whatever we are getting, let's start with it. Because we knew that once we start doing our work, and once slowly and steadily they develop the relationship of trust with us, they'll come out openly and share the information which we have. So we studied all the files, and we found that 2 people had, out of those 37, 2 people had committed suicide. One was died because of an accident, because the water tank had fallen over his head and he died. And rest of the 34 cases were because of the medical reason. They said it's a natural cause of their death. Now who is to blame? And also the record shows that not even a single person has been given compensation in these 37 cases because the jail authority is not ready to take the burden on them. They don't want to own the liability. They said it was act of God, it was natural death, so we need not to be blamed. Okay. They need not to be blamed, then who need to blame? The prisoner who had died, he will not come to give the justification and what were the reasons involved in that. We interviewed the doctors. After reading the files, we interviewed the doctors and they said there is a huge vacancy in the Tihar jail. There are 100 posts which are authorized and we have only 50. It means like half of the seats are vacant. There are 12,000 prisoners, only 50 doctors are there to take care of the patients. Then as we checked their records, we found we checked record of all the doctors who are working in the Bihar jail. All the jails have attached dispensaries to it. We checked the records, and on the basis of data which we collected, we found that on an average, every day 941 cases are coming before the doctors. And if we divide it with the number of doctors which are available, that is 50, it comes down to 20 patients per doctor. But it's not that unreasonable. I think a doctor can take care of a patient, like one doctor can take care of 20 medical complaints which comes for it. Then what else? Is it a medical negligence which they are trying to hide under the name of inadequacy of staff? Because nobody takes that much of pain of checking their records and then collecting the data and doing such analysis that if on an average every day 941 complaints are coming, we have 50 doctors, so it comes down to 20. One doctor can easily treat 20 patients in a day. So it means it has something else to do with it. Then they came, and another part which we came to know is, if their problem is not great, then they treat it. If their condition is more complicated, then they are referred to a bigger hospitals outside. That also is recorded in their medical record which is maintained. And after taking out the average, it came that 54 patients are referred every day to outside hospitals. Now, I said that if they are referred to outside hospitals, so, and in almost all of the cases, it has been brought to the record that they died when they reached the hospital. Brought it. Like, what is the reason? They said there is only one police van which is available, which accompanied the ambulance. Earlier, the jail staff was taking the prisoners to the hospital, but because of some running away instances, now the Delhi police van accompanied the ambulance, and there is only one police van which is available. So if police van has accompanied one ambulance to a doctor outside hospital, and in between another company come in, he cannot be taken to the doctor unless if the police van comes back. Because of which a person remains in that critical condition for hours, and because of it sometimes he dies. This is the same situation which happened in a particular case, that is Nina Ranjan Pillai, which has become a landmark case, in which the person who had died, it was shown the record that he died of natural death. Because he had some problem in his liver, he was bound to die, so he died. But as he was a rich man, wealthy man, his wife for the case, she brought the medical report that it's right, my husband had some liver problem, but his condition was not that complicated that he could have died so early. That's right. People suffer from many ailments, but that doesn't mean that they'll die so quickly. It is because of medical negligence that it preponed their death, and then they aggravated the matter. This is the case of clear medical negligence on the part of the jail authorities. And in this case, Justice Muller laid down that state is strictly liable. They cannot say that we tried a level test as per the available resources to save that person. No? The moment a person comes within the custody of jail authorities, it is his duty to take care of him. They are strictly liable, and in such cases, not only the doctor and the jail authorities, both should be made jointly and severally liable, and he was granted compensation of rupees 10 lakh. This would have been possible in this case because he was in that his family was in that financial position that they could afford the hiring of advocate, and they were not worried about the money. But in rest of the cases, their sole bread earner has died, the family is in financial crisis, the immediate thing which they have in their mind is to get some work so that they could carry on with their life. We cannot expect in such a situation from the family members to take up the case and fight for the compensation. So I think it is an nexus to justice because of the financial condition. And the last point which was brought to my notice after analysis of the data was, whenever a person dies in a police custody, the magistrate is required to submit an inquest report as per section 176, 1A. But we have found when we were reading the case file, we found that there is a case file of 2013 has the inquest report because it generally takes 1 year. I could not understand why. Inquest report is a report which is filled on the spot when a person dies. Before you dispose of his body, before you bury him, you need to get him examined by a magistrate. So if he has written it, why is he taking 1 year to submit the report? In addition to the inquest report, he is required to conduct an inquiry. This inquest report might have been written, but it needs to be coupled with the inquiry report, which takes 1 year. But I don't understand why does it take 1 year. And once he submits the report, which is generally he submits that he died because of the natural consequences, who takes up the matter? Nobody takes it. Like for example, one case, a person died because the water tank fell over his head. It's a case of accident, or it could be the negligence. Why didn't they maintain the water tank in such a situation that it should not fall over the head of a person? Like, why not compensation in this clear case? In other cases, you are taking clear that it could be the medical condition in which he was. Even he could have died if he had not entered the premises of the jail. But in this case, this person died. And suicide. Suicide also, I think, it is somehow related with the medical facilities which can be provided in a jail. If we provide proper psychiatric counseling to them, they might not commit suicide. So I think it's a clear-cut case of medical negligence, which they are trying to hide under the tag that inadequacy of staff or he was terminally ill. And the last task which we do in our clinic was preparation of the legal literacy material, because when the laws, rules and regulations are so complicated, which are beyond the understanding of even the advocates sometimes, we get confused about the interpretation. We cannot expect a layman or a prisoner to understand it. So what we do, we simplify the existing law and we conduct awareness camps so that they could be made aware of their rights. And once they are aware, they might ask for their rights. And the moment they ask for their rights, it would put check on the arbitrary exercise of the power by the jail authorities. Thank you.
Thank you very much, Rajvi. I think what your presentation shows, in the way that I think Ms. Shankar's presentation yesterday shows just how much valuable work, both in your case, primarily advocacy, but also research, in your case, research and pro bono support for individuals and for a whole institution really, can be done on really quite limited resources. If the will is there, if the intention is there, if people are in the right mindset, and your comparison, the comparison of your work with the work of the doctors brings that to light. And also you've raised the recurring theme of the whole conference, I think, the problem of access to justice, inequality of arms that we're seeing again and again in different cases and different settings. So your example of the woman who had resources, who had some power, and was able to litigate in order to find some accountability and some compensation in the system where everyone else doesn't have access to those resources, is depressing in the extreme, but not terribly surprising, and terribly surprising in most jurisdictions. So I'm going to open the floor. I mean, just really to say it's just a very impressive work you're doing. I'm not sure that you're aware of that, because sometimes when you're in the middle of doing it yourself, you're not aware of quite what you're doing. But interviewing 8,100 prisoners is a colossal piece of work for an enormous research team, but to do it with a bunch of students basically is amazing. So my congratulations to you. It's really excellent work. I think Professor Pandey wanted to come in now and sort of pull together some thoughts on the morning so far.
I'll briefly make a comment on access problem and lack of access problem. Access to justice is premised in an adversarial system that we have in our that we follow, adversarial system of criminal justice. Access is a precondition of moving the adversarial system, both as for the accused as well as for the prosecution. Now, if there is lack of access, that is an indicator of wrongness. If there is lack of access, that is an indicator of miscarriage. And so far we have not been able to see it from that point of view. Wherever you organize access to justice, which I remember in 1977 with my students in Delhi University, the Trafficking Act, or it is a juvenile or it is a Dalit, and their cases are, majority of cases are those that reach the appellate court stage or the Supreme Court stage. So it is they constitute a large percentage of criminal trials, not the upper caste, not the people who are well-off. Well-off people are once a while, but majority of them who constitute the prison population. Nicola Lacey, in her writing, one of the writings used by Ellen Norrie, showed that even in the Western world, the prison population is largely constituted by the underclass, and that is maybe that may be the reason why in 2000 Ellen Norrie wrote that book, that the basic Kantian premise seems to have broken down in UK and Wales because of economic disparity. If the prisons are full of them, if the courts are full of them, if the lawyers are earning through them only, they are already impoverished, and lawyers earning through them, through vagrants and through juveniles, is a very sorry plight, but then that is the reality of our criminal justice system. And but again, what I said, there is lack of information, there is lack of empiricism, there is lack of, we need to flood these sick and torturing institutions with information on their face, tell them that you are only working against the poor population, marginalized sections, and there should be evidence for it. Not rhetoric only, theorizations only, there should be evidence for it. But that seems to be, we seem to be lacking in on that aspect for the moment. Stop here. Thank you.
Professor Rao, would you like to go next, and then we can open it for discussions to all of the people who presented.
I would like to deal with three issues. The first, observations on the two presentations, second on wrongful arrest and detention, and the third, my observations on follow-up. I think in the first presentation, Maya has explained the main two important issues. So, in fact, when the criminal justice system goes wrong, and why the criminal justice system goes wrong. Particularly the issues relating to police transparency and accountability into functioning of the important agency of the criminal justice system in India. I think she has rightly explained, but I would like to briefly categorize even in to study the systemic reforms of the police into three important phases. The first phase is when India attained the independence 1950 to 75, 75 to 77 is an important phase in the Indian legal and constitutional history. The dark days of emergency, that was the time internal emergency was imposed. Whoever is studying the constitutional history or criminal law history, primarily they divide into pre-emergency and post-emergency. So 50 to 75. In fact, very interestingly, if I remember rightly, Khosla Commission in 1958 has rightly said when the Indian police will become the people's police. Then we had the very dark days of the, I think, 19 months of internal emergency between 1975 to 77, where even the writ of habeas corpus was suspended by the Indian Supreme Court. So let's look at what happened. Is there any change in the picture of the culture of the Indian police? 1975 to 93, again, we study again the history into pre-globalization, post-globalization. So 75 to 93, is there any change? There are several initiatives, particularly post-emergency resulted in the National Police Commission 8 voluminous report Maya started and CHRI started an advocacy around. Several things have happened, and post-globalization 93, last 2 decades, nothing perceptible change in the police culture and accountability. Deterioration, yes, absolutely. Yeah, invisibility of the deterioration, acceptability, yes. So the issues we have to look at, the legal accountability, and Maya has said community policing could be a model. What are the internal oversight mechanisms, external oversight mechanisms? Again, CHRI has done an interesting work. I think still they are continuing in the prison oversight mechanisms and police oversight mechanism. Here, 1997, the National Human Rights Commission in India, under the leadership of Justice Venkatachalaya, first time initiated the external oversight mechanisms in the police station. I think somewhere it was lost. I think that needs to be looked at. And I wanted to primarily focus on this important issue linked to transparency, accountability, is the police subculture prone to violence. I may be biased because I may carry my own baggage of coming from a civil liberties movement in India. As when I was a law student, I have seen, and in fact we started with this. So pardon me being an activist, being a bias in looking at the criminal justice system. I may have my own human rights lens sometimes. But that's what is the police subculture prone to violence is the major problem. I don't think we have moved from that. That is the basic problem of how do we create a people's police or a democratic police? How do we introduce internal mechanisms, external mechanisms, which will never work. So I'll move from there to link to the wrongful arrests and detention. I think being arrested is a frightening experience. I was active in the student days. I was in the prisons 2 times on students' issues, something. Okay, I think that's a real, if you are arrested, real frightening experience. I don't know how many of you have visited a police stations, not as an accused or other, but you should go to the police station and see, go to the prison and see several of these custodial issues. Policing is a public service, but we never think about, even a common citizen in India can walk into any of the government institutions, a revenue office, a land registrar, anywhere, but he thinks twice, he or she will never dare to enter into the police station or prison. Prison is a closed environment. Those you require permission, but police station is a public place. So that's what arrest. And arrest is a typology of several kinds of arrest. Arrest and detention, you have a criminal procedure code, you have a constitutional safeguards, you have several interesting judgments of the Indian Supreme Court, you have United Nations standard, minimum standards for treatment of prisoners, international human rights, several things. But ultimately, all these have to be honored, observed by a police constable in the police station. 24 hours a person has to be immediately produced before the magistrate. This first 24 hours of detention is a horrible experience. I don't want to give anecdotal, several cases of this. I'll give one case where one person was arrested and there was a mosquitoes in the police lockup. He died in the police station because of the mosquito bite. And aseptic, there was no treatment. So several of these stories and these were documented. Cases came before commissions of inquiries, the Supreme Court, High Court. This is what a pathetic condition. There is no external, internal monitoring mechanism till I quote in these 3 landmark judgments of the Indian Supreme Court, 1983, Sheila Barse versus Union of India, 1996, Joginder Kumar, Justice Venkatachalaya, 94, Sheila Barse, 85, 96, Joginder Kumar, Justice Venkatachalaya borrowed from UK first time. How do we document arrest? Custody memo he borrowed from the UK Police and Criminal Evidence Act in 1997. It was further improvised into D.K. Basu, several other things, but still the issue remains that 24 hours of detention, arrest and detention. And there are several kinds of arrests. In fact, somebody was saying that this is a social and legal aspects of arrest. Right? Once a person is arrested, because all family relationships will be break down, the sole breadwinner, the wife and others will run down, they will sell off whatever they have to get him released, and particularly women will experience a, in fact there's a criminal procedure code safeguard said women should not be called to the police station, several things. And juveniles, towel arrest they call. Towel means a small cloth which is there with the on the hands of these juvenile person. They know that these are the juveniles. They were arrested in the railway platforms. So there are several typologies of arrest, and arrest creates a custodial trauma. And sometimes the deaths in the police stations, deaths in the prisons are primarily because of this, because they do not know when they will be released, how long they will stay, even though law says 24 hours, but when you have several remedies available in the criminal procedure code, search warrant, or you have a writ of habeas corpus in the High Court, Supreme Court, but when they move immediately, they are shifted into another police station and several other things happen. So this is the social aspects of arrest, legal aspects of arrest and detention, and that leads to sometimes even it will facilitate quick death in the police station. So National Human Rights Commission, Amnesty International, and several of these reports, annual reports will explain about the number of deaths. So there is no transparency, there is no accountability, very few. In addition to that, to prosecute a public servant, there is an interesting provision in the Indian Criminal Procedure Code, section 197. There is a prior sanction of the government is necessary for prosecution of the public servant who is responsible for the death in police custody, or death in prison, or extrajudicial execution, and several other things. So this is what the problem is. How do we create or transform the police subculture which is prone to violence? How do we democratize? This is a larger issue. How do we address this? How do we make it? How people can easily walk into the police station or a prison? I think that's where an important issue. Professor Bajpai explained about the importance of empirical research, but I disagree with him that critical debates cannot wait till empirical evidence is available. Yes, empirical evidence is necessary. It is, but we should look at the pre-trial criminal process, the several issues which are coming up. I think this is necessary. We should look at several of these indicators, yardsticks and parameters. There's a high time we should move from having an empirical evidence, but pre-trial criminal process methods of some of these already are documented by the Indian Supreme Court and various high courts. I think it's high time we should focus on. Lastly, I do not want to take much time. If there's any questions or something we can look at. Follow-up. In fact, I was the main culprit, the person instrumental and responsible for this dialogue. Initially, I was, when I visited Oxford in January 2014, that was the time at NLU Delhi we were moving towards seriously looking at how do we create empiricism within the research in the Indian context. And we had several of these workshops for the law teachers, researchers, social science. We have brought several of these, not only law teachers. That was where I met the Dean Oxford and I had a discussion with Caroline. We thought, let us share the experiences, how do we learn from each other. Then we had an interesting discussion with the inputs from Professor Pandey and Maya. Then we said thematically we will look at within the criminal justice research, when the criminal justice system goes wrong, why the criminal justice system goes wrong, how do we create, how do we look at the parameters, indicators or yardsticks, and how do we work together in the comparative research, and keeping in mind the core periphery issues which are relevant, contemporary in the criminal justice system for the next 10 years. I think that's the follow-up I want. In that follow-up, I think currently I have moved from, I hold my 5 years position of the professorship is here and part of the National Law University Delhi, but currently I am located in the National Law University in Orissa. So the National Law University of Orissa would be happy to be partnered with this next 5 to 10 years, whatever we plan. How do we take it forward, the criminal justice system? How do we improve the performance and efficiency of the Indian criminal justice system? And both we can identify the core issues, periphery issues, what is achievable, what is in the long run. I think that's the purpose. I'm glad that we are moving towards that direction. Thank you.
Thank you much. Thank you very much, Professor Rao. Lots of issues still sort of hang around the table, or hang around the room, lie on the table, whatever the expression is, that I would like our audience to have the chance to you're so keen, to pick up now issues around social justice, obviously, and policing for whom, criminal justice for whom, etc. So you go ahead.
Thank you. See, in case of wrongful confinement or wrongful arrest, the state may be held vicariously liable, and it has been held by the Supreme Court in a number of cases. This is Bhim Singh versus State of J&K, Rule Shah versus State of Bihar, where the state was held liable to pay the compensation. So my question is whether the doctrine of personal accountability can ensure the accountability of police officers in case of wrongful arrest.
Was that specifically Professor Rao? Yes.
Sorry, just repeat once. I thought you were making an observation.
See, in case of unlawful arrest, state may be held vicariously liable. It has been decided by Supreme Court in a number of cases. Where that state, Bhim Singh versus State of J&K 1984, Rudol Shah versus State of Bihar. And in case there is a doctrine that has been evolved by the Supreme Court, a personal accountability, public accountability of public servants, where that public servant shall be held liable and shall be directed to pay the compensation. State will not be liable, public exchequer should not be misused for that purpose. So my question is, how come this personal accountability or public accountability of public servants can ensure the accountability of police officers for wrongful arrest? Thank you.
There is a 1983 onwards, the Indian Supreme Court started a compensatory jurisprudence, and the National Human Rights Commission also had a primary mandate which was set up in India in 1993. But there's still, as critics have said, there's a waywardness in the Indian Supreme Court or high courts in the compensatory jurisprudence. Personal liability is a very difficult issue. Theoretically, idealistic notion is really good. The person who is responsible for a torture or a death should be punished. But how do we get that money when he is suspended? There are several of these practical issues. There are cases where the courts have awarded death penalty and directed that the money should be collected from the salary of the individual police or other person, and also entry should be made into their confidential records. But it's very difficult to implement it. There are cases, but very few cases. There is still waywardness in the compensatory jurisprudence in India.
Thank you. Ian had a question. Oh, sorry.
That's okay. I'll wait.
If I'm allowed, I actually have a question and I have a comment. The question is, well, it'll end up being this when I get there. One thing we know about police organisations is that they're kind of shaped in important ways by their environments. And their environments can be legal environments, political environments, the pressures of different kinds from different kinds of publics. And in other words, that when we think about police, we need to think about police cultures and we need to think about cultures of policing. And I think, unfortunately, we know more about police cultures than we do about the cultures of policing. In other words, we know about the environment and how that shapes what police forces do. And the question in this context is, and I say this as an outsider, when people in the room just talk about the Indian police, do they mean a single organisation, or are there in fact important interstate differences between 28 Indian police forces? And the reason for thinking about the latter is that if there's any mileage in thinking that actually there are 28 Indian police forces, not one, one that raises an important kind of empirical and explanatory question: is there differences between them? How do we explain those differences? And might those differences have something to do with the cultures, the political cultures in which those forces operate? And also, there's an obvious kind of reform issue that opens up there. I mean, it might be that some of these police forces do certain things better that we've been talking about, just better or worse than others, and other things that can be learned about the forces that do things better. And I'd just like to know a bit more about that. But my comment is about the police, about the kind of police reform agenda. And I think this is true whether you try and whether you're in the business of trying to change organisations that currently exist, or your intriguing strategy of just scrapping them and starting again. And I think that there's a tension that arises here, and I'll try and describe what I think it is, between what you might call a rule of law project and what you might call a democracy project. The rule of law project, as Professor Pandey has articulated, is about just trying to get police forces to subscribe to and keep to the law. It's about bringing the police closer to the law, putting in place enforcement and monitoring and redress mechanisms when that doesn't happen. And that's one way to go, and there's an important way to do it. The democracy project involves actually trying ways of bringing the police closer, not necessarily to the law, but to the people, and either finding or creating political structures through which all citizens, and not just the powerful, can have their experiences of crime and their demands for police resources actually listened to and heard. Now, there's all kinds of ways in which those two projects kind of reinforce each other. And to some extent, if you can get the police to subscribe to the rule of law, it might increase levels of trust and confidence. It might be people more willing to report crime and so forth. But there's also a tension, and I think the tension is best described in the following way: that the rule of law project involves separating the police from politics. It involves creating barriers between the police and political systems. The democratising project actually involves bringing the police and politics closer together, at least to the extent that one of the ways through which you create opportunities for people to exercise their voice over policing organisations is through political structures, either the ones that you're currently you have, or ones that you might wish to create.
Gosh. Yeah.
Would you like to answer us?
Is there a difference between different police forces? Yes, there is, and between the cultures and where you begin. And we think about this very often. We have, as I said, we're not a research organization, we're an advocacy organization. And so when I talk, I'm not talking from deep research. I'm talking from all the things that we experience every day, the conversations that we have. And of course there is a difference, there's a tremendous difference, and they will uphold that difference when you're talking to different police people from, say, Bihar and Kerala. They don't want to be identified with each other. Certainly Kerala doesn't want to be identified with Bihar, or UP for that matter. So there is a great merit in looking at what makes them the way they are, both internal cultures and external cultures. But that said, then eventually we have to go toward reform, whether you look at it from the lens of a democracy project, or whether you have to look at it from the project of a rule of law thing. In the end, the police have to be a service. They have to be a service that upholds the constitutional values that we have all wedded ourselves to. Of course, they are shaped by the environment, and of course, they are one of the reasons why we don't get the question that the lady was asking earlier about how much buy-in do we get from the public. Very often we have to be very, very cautious about the kind of buy-in that we ask from the public, because the public is not looking at, or not even desirous of, rule of law policing. What they want is just policing that will sort them out through the day. And they don't much care how it's done. You can't get that much sympathy. I don't know what your experience has been, Professor, but you don't get that much sympathy for torture. You can talk about it in the halls of justice, you can talk about it in subcommittees of Parliament, and they'll say all the right things, because they're actually facing, the audience that they're facing is the international community. they're not facing our local communities here. I'm not saying that our local communities are bound and in love with torture, but they don't see alternatives to the immediate expediency that they need to face. So I think that you educate my mind when you talk about a democracy project versus a rule of law thing. But I think eventually when practical work may come together. When we talk about police stations like KDR was talking about, one of the things that we are trying to do, and the conversation we're trying to begin, is that we don't have to wait for structural reform, we don't have to wait for legislative reform before we reclaim the police station as a public place. But so that would take us to, as you said, the democracy project. But the police station in the public space cannot be a place where you go and say, torture my friend here because I think he's done me wrong. So it mixes in with the necessity to keep the rule of law. I don't know if I'm answering your question at all, but I think what we find is that we as an organization, we pick on all of the things that we can that take us somewhere. Is that, do you want to add to that? No.
It was less of a question than a comment. I think you've clarified the point that I was trying to make, that in all kinds of ways these two projects can overlap and mutually reinforce each other, but there are points of tension. And the point of tension you articulated when you said, no, that there are sections of the population who their demands for policing aren't demands for rule of law policing, they're demands for something else.
And I think there's one thing that Caroline also touched on is when you're talking about research, I think that micro studies, really micro studies like the stuff that we do it because we have limitations of our own finances, capacities, and so on. But I think that micro studies aimed at local areas of influence have a tremendous potential. And in India, they're exceptionally inexpensive. And I think that is one thing that I will urge that we continue. As far as comparatives are concerned, I think comparatives are a little bit more tense-making, because the culture in India, from what I have seen of the establishment, is to reject that which is done elsewhere. The thing, the quote is, India is unique. There's no other country like it. We are evolved differently. Our democracy is at a different stage, and depending on who's in the room, it's an old democracy, or it's a new democracy, or it's a democracy that is evolving, or it's a democracy that nobody else has seen. So I would be careful about how I phrased the comparative. The other thing is, you said 5 years, 10 years. I agree. 10 years and 5 years is a really realistic horizon to be looking at. At the same time, I'm always looking for that particular. I'm so glad that you're having this discussion, and all of you are also learned when you're having this discussion, because in the end, the research has to have a purpose. With me, it's not an academic issue. It's a purpose. And the purpose is to get a better criminal justice and a reforming kind of system. But what is that particular prioritization that will press the button? This is an analogy I often use. The dark room, which is the correct light switch that will illuminate the whole room and not just a single area, which will make that change. Because that's what we're all yearning for. We're not really sitting here thinking about what are we going to do with the next piece of research. We're really thinking about what are we going to do to change everything. And I don't know where that everything is, but I keep on hoping that maybe that will be.
No pressure.
One thing that is something that we discussed over tea in terms of research is my hypothesis is that there's role confusion across the system. I work with the judiciary, and that's what I was sharing with judges. Why doesn't a magistrate look up to see whether there's someone before him or her? Is because the magistrate is not seeing his or her role as to have to look up. So I would take what Professor Bajpai said earlier in terms of this, and disagree with you. With all the hypotheses that he put forth, having worked on that area of trade law, is the problem, and as Mr. Agarwala said, is how we imagine the police. So when the criminal amendments happened last year, we introduced a provision in the Indian Penal Code saying if a police officer does not register a report relating to rape or any other sexual offense, you will prosecute and punish them. So you're holding the person criminally accountable. But what happened? People see the Indian police as someone I would go to if I have a dispute with my neighbor, if I have a dispute with you about something else. And they're looking at the police as someone who come and adjudicate between the two of us. So here, and that's what the study that Hindu does, which Professor Bajpai was referencing to, it's an excellent study of 3 parts of the report, and read the entire story. It indicates that someone goes to the police station saying that, look, a woman goes to the police station saying, I was in a relationship with a man and he's broken it off. And what are the police doing? They're saying, why don't you register a complaint of rape against him if you had sex at any point in time? And then you register all those cases. It then lands in the court, which says the law is being misused. But you're not going to the core of trying to study why is it that all these FIRs are actually being registered. And so that's the sort of micro level study that you need to do, not look at wrongful convictions or in that context. You need to see why are those FIRs actually being registered. Has 168, the provision that is introduced, actually become counterproductive? Is there a question of role confusion in the police of what they are supposed to do in these cases of rape? And I think that sort of work is what is needed. So then when you're doing law reform, you really actually press the right button instead of just changing the law wholesale and then ending up with counterproductive results.
Did you want to comment on that?
I think I was wanting to respond to Ian's projects, rule of law project and democracy project. I don't see that we see here these two projects in contradiction with each other. They are complementary and supplementary. And if the second project has to wait, it has to give way to rule of law project. My understanding is our wrongness of our system is largely because of lack of rule of law. There is not lack of democracy, it is lack of rule of law. Maybe in both ways. When democracy becomes stronger, rule of law will become stronger also. But the culture of rule of law is an idea that came from outside, and it believes, say for instance in our society, the big problem that has still not occurred, but I have great hunches of it will occur at one point of time or the other, where majoritarianism would like to rule. You have to strengthen rule of law that even majoritarian wish cannot overrun rule of law. Rule of law is our constitutional foundation, and therefore we have to strengthen the rule of law project. And the lack of role ambivalence in the criminal justice administration agencies' understanding of their role is largely because of rule of law not being understood by them properly, lack of awareness of rule of law, lack of understanding of rule of law. Therefore, we have to bolster them with evidence, information, field-based information, that you have not understood your role. Mr. Prosecutor, you have not understood your role. Had you understood your role, you would not have connived with the police investigation. Mr. Magistrate, you have not understood your role. Each one of them has got to bring a healthy criminal justice administration. But each one of them is conniving with the other in bringing a sick criminal justice administration. That is at the end of the day, that is what is happening. And Supreme Court, in large number of cases, how many correctives can the Supreme Court? And I was talking about when Professor Bajpai was talking. Now, see for instance, in Aksharnam case, the trial court judge has on the same evidence convicted them and given 3% death sentence. The High Court has confirmed the death sentence and upheld the conviction, life imprisonment for 6 of them. Now, if you do empirically, The appellate court judge, there's only one judge, Gopal Gowda. Two judges versus one judge. Now, because in appeal stage, that is normatively determined. The correction can come at the High Court level, at the Supreme Court level. That is the beauty of rule of law project. That one court commits mistake, the second court commits mistake, repeats it, the third court, highest court, checks it. So you right the wrongness of criminal justice administration. Therefore, rule of law is to be strengthened much more, and for that you need evidence. For that you need more information. For that you need more empiricism, and that is where this project on any of these things. The policeman will say, "ये तो आप अपने मन से बता रहे हैं." You are saying out of your own thinking. This is a generalization. It doesn't happen. You don't have any idea of a criminal. Criminals are very hard-bound. You think that they deserve certain human rights. They don't deserve human rights. Now, he is ignorant. You have to tell him. You don't know. You are subject to rule of law. The rules say that you cannot do it. The rules say you are supposed to do something else. 169 says you are supposed to, wherever there is suspicion, release the person on bond. You have the power to do it. How have you done? You have never done it. Because he is in, whatever you say, culture of police, policing culture is violence culture. I feel it is lack of rule of law information.
Ben and Sarah both had questions. I suggest, because we're running late, that we take both questions together and then just allow for one last response.
Mum was just a comment about the issue of accountability, so that's quite a long while ago, so leave it. I mean, the point about personal accountability of police officers, I mean, on one hand, of course, police officers are personally accountable for what they do. If a defence doesn't apply now anymore than it did then. But that's kind of a get-out clause for a police organisation, and it is used as a get-out clause for a police organisation. So we've had many police scandals in the United Kingdom over 50 years. Every time we have a police scandal, it's a rotten apple in the barrel. All we have to do is get rid of this person, and everything in the garden will be rosy. So personal responsibility is used by the police organisation as a tool to get around structural reform. And of course, what should really happen is within the organisation, individuals shouldn't be making those kind of decisions without checks and balances. And once the checks and balances are in place, then the organisation as a whole becomes responsible. And that's slightly complicated when you're dealing with police officers because they are empowered to make arrests, and no one's going to second guess the arrests they make on the street. Very rarely are they going to make. It's what happens after that, I think, and then you have to implicate the whole organisation in that process. Otherwise, they will continue to use it as an excuse for not making a change to the relationship.
That's a really important point. Thank you, Sarah. Did you have that? You could put it out there, and then if people wanted to talk to you over lunch, we could do that.
This is really a question for Bharti and Maya around when you do get access, do you have any restrictions on how you use the data you collect? If your organizations say you need to run it by them first, if you want to publish something, or if you were mentioning at the break about work you've done, but you then don't have access to share it. I'm just curious about that. Thank you.
Actually, I had an additional supplementary to Bharti on that, is that when you struggle so hard to get into the prison and to get access, to get the trust of the prison authorities, but then when you start being critical of them, what happens? Because we are at that stage now where we like to get critical, but what do we do about that?
This question came into my mind as well, and I settled down the point in my mind by believing that if this criticism comes with the cost of my access to the data and keeping my students out of the work which we are doing, and by that my students are getting to learn the practicality of the law, and I need to suppress my critical analysis and open criticism there, because my ultimate aim being a clinical teacher is to get my student practical exposure, and while doing so they get to learn the practicality of the law. So to start with, it's an easy way of not being so critical, submitting a report by being a part of that institution instead of standing as a different institution and pointing out the mistake, loopholes and recommend that institution, then they would start justifying their act by giving any reason which they wish to. But if you become part of the institution, when you say that we want to work with you and we would like to assist you, and whatever suggestions we are giving, it's up to you how do you accept it. Once you win the trust of these people and they don't see any threat in you, they become more receptive, they become more friendly, and they become more gracious.
I'd like to add to that, as an academic institution, especially, we get a lot of access to prison police and all of that, and that's where we come up against things, and how do you respond, how do you put out a report. And I think one thing that we do, and I think Professor Rao, we've done multiple projects earlier, is prepare a report. As an academic institution, nobody can stop you from reporting what you have done, and you don't really need to critique it. It's evident the way you presented what's happened. For this one, the state to take notice of what happened, and for other people who want to use that data to critique it. And I think the question is, how do you put it out, and what's the role of an academic institution taking both the issue of not losing complete access so that your students learn, at the same time ensuring that there's some change that happens in the
We
process.
need to maintain a balance. We cannot be too critical, or we cannot publicize the criticism.
I think all academic institutions are struggling with that one. We certainly are. It's a constant. Thank you, everybody.